Welcome to Employment Law This Week. I'm George Whipple. Our top story, the NLRB rules employees have the right to discuss arbitration proceedings with colleagues and may not be required to arbitrate claims under the NLRA. The board found that Dish Network violated the act when it tried to prohibit an employee from discussing his suspension and an arbitration brought against him. The board also concluded that the company's arbitration agreement violated the act because employees could believe it prohibited them from filing charges with the NLRB and other agencies. Adam Abrahms has more.
I think the issue that are raised in the Dish Network case really do kind of remind employers that even though there's been a lot of controversy around class action waivers or how HR investigations are taking place, and there's some hope that maybe we see some change in the law as a result of the Supreme Court or a new board under the Trump administration, the core tenets of the National Labor Relations Act remain the same. Employees have a right to bring a charge before the NLRB, and therefore any arbitration agreement should include a carve out to make it clear that employees can still bring board and other government agency charges. They also should be making sure that employees are not prohibited from talking about their basic terms and conditions of employment with one another.
Lawmakers asked for a reversal on the EEOC's Equal Pay Data rule. Senators Lamar and Pat Roberts have asked the Office of Management and Budget to block the addition of compensation reporting requirements to the EEO-1 Form. Beginning March of next year, the rule will require businesses with 100 or more workers to send the agency pay data categorized by gender, race, and ethnicity. The senators called the rule misguided, pointing to discrepancies in cost projections and concerns over data security. A new South Carolina law prohibits local municipalities from enacting laws that would require private employers to provide benefits like paid sick leave, paid vacations, and paid holidays. 17 other states, including Alabama, Florida, and Tennessee, have passed similar preemption laws. The law is designed to ease the burden on employers who could otherwise have to contend with different legal requirements in different municipalities. And in other state employment law news, Colorado lawmakers have passed the Wage Theft Transparency Act, which opens the door for public disclosure of employer wage law violations. The Justice Department drops its lawsuit against North Carolina's so-called bathroom bill. Federal officials said they dropped the suit because the law, which had been called the most anti-LGBT legislation in the country, was repealed last month. But LGBT groups in North Carolina and elsewhere have sharply criticized the replacement bill, which gives the state legislature sole authority to regulate public accommodations and prohibits local governments from enacting non-discrimination ordinances. These groups have vowed to fight the new bill in court, despite the Justice Department's decision. Now it's time for our tip of the week. Joshua Ehrlich, chairman of the Global Leadership Council, is here with some advice on the best way to use executive coaching.
In the first situation, the classic example is a bull in a china shop. A person who is under stress or never learned how to focus on their impact on other people and has to build their self-awareness, their ability to self-regulate and manage themselves. In this situation, the frame is negative. Over the last 10 years, coaching has moved to become a more proactive problem solving where it's about building leadership capability. And here, a leader is looking for their next assignment, transitioning into a new role, and really the company is trying to invest in them and get the most from them. The frame is positive, so the individual gets more out of it, they're more engaged, and the company gets more value.
Thanks, Joshua. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.